By contrast, consider the much more notorious case of Dred Scott versus Sanford, decided by the Supreme Court of the United States in the same year as James versus Carper, which involved a much more complex set of facts, raised matters of national importance, and traversed a much more circuitous path to resolution of its underlying issues. Generally speaking, Scott should be classified as a freedom suit. Nevertheless, when Dred Scott and his wife filed suit under Missouri law, they alleged the intentional torts of battery and false imprisonment, which should have entitled them under the state law at the time, if successful, to claim money damages. Such damages would not have been paid by the defendant in the freedom suit, but would have derived from the labor of the plaintiff, who was typically, under Missouri law, hired out to an employer by the court during the pendency of his freedom claim. On the other hand, if the plaintiff was unsuccessful in proving that he had been wrongfully enslaved, the fund created by his labor would be paid to his master. And this procedure ensured that even if slave masters who had wrongfully enslaved blacks would not be required to make restitution to the persons they enslaved. Whereas the worst outcome for a slave master would be loss of a slave, the most that blacks could typically hope for in such suits was to win their freedom from bondage. Antebellum slave law ensured that even these uncompensated victories were rare and hard to come by. The Scots, for instance, fought for their freedom in the courts for over 11 years. In the end, Justice Taney, writing for the majority, concluded that the Scots were not free persons wrongfully enslaved, and that even if they had been free, they could not be citizens and had no rights that the white man was bound to respect. Time? Okay. So, so that's where I start this discussion of whether or not restitution would have been possible for the enslaved. Generally, it was not a possibility for the enslaved. There are some exceptions, but they're relatively few. And often they only involve nominal damages for the slave master. So to those who say, well, you're time barred, African Americans, descendants of slaves who are time barred today, well, when there was no time bar, they still couldn't sue. And when they had standing, they still couldn't obtain restitution. And so the question that I ask as someone who's intensely interested in seeing redress for this historical injustice is, when is the time, when would have been the right time for redress? If the time of slavery redress has come and gone, Stephen Best and Saidiya Hartman suggest that by 1787 it was already too late. It is necessary either to, one, choose a date when redress was made, naming the elements of that redress, or two, to choose a date when the possibility of meaningful redress was lost, outlining the reasons for the loss. Best and Hartman choose the second path, concluding that the incommensurability between grief and grievance, pain and compensation by the end of the 18th century had become an unbridgeable chasm, and that the most slaves could reasonably expect was perhaps abolition. Unfortunately, conservative critics of reparations for slavery implicitly hold that the time of slavery's redress has passed, and explicitly name policies such as affirmative action or fair housing laws or abolition itself as elements of redress, but refuse to state any date on which redress occurred. As Ariella Gross points out, conservative histories of slavery are linked to a narrative in which freedom was inevitable, slavery and Jim Crow were transient deviations from the American creed, the Republican Party is the champion of civil rights, whose true meaning rests on a timeless principle of colorblindness embedded in the federal Constitution, and finally that American slavery, resembling slavery in the ancient world or other parts of the world, was not a racial institution. This tableau of commitments permits some conservatives to conclude that no single group, in other words, whites, clearly benefited from slavery, that few whites owned slaves or benefited from slavery, that most blacks did not suffer from slavery, and therefore that whites as a group do not owe blacks anything. In In re African American slave descendants litigation, the court invokes the narrative device of slavery as a stage transient to inevitable freedom, while refusing to hear the plaintiff's arguments on the merits and dismissing their lawsuit for reparations on procedural grounds. In the course of constructing its own narrative of redress for slavery, the court makes plain in dicta its belief that slaveholders who lost their property as a result of the Civil War, Union soldiers who lost their lives in the war, and subsequent generations who suffered social, political, and financial losses due to the war paid the nation's debt to the slaves. In the zero-sum approach of the court, it seems any loss suffered by whites linked to the abolition of slavery, regardless of any consideration of legal or even moral entitlement, represents restitution for slavery. I try to follow a more rigorous methodology, a methodology that tracks some of the concerns that I see raised in whiteness as property. Slavery, instituted as a line demarcating the Christian from the non-Christian servants, gave rise to this national racialized identity, whiteness, that was meant to be passed down from generation to generation like property, to the everlasting exclusion and detriment of those who had been held as slaves. And the confounding relation between personhood and property, between citizenship and race, between law and commerce has left its mark long after the exigencies which gave rise to the confusion of the categories have passed, thus giving critical urgency not to pass over the point in the U.S. legal history when persons were absolutely property before they were not. Okay, unfortunately, I'm out of time. I have a lot more here, but I'm going to try to be a team player.
Hi. So it's really a great pleasure to be here as part of this panel and to help honor Cheryl Harris, who's been such a wonderful mentor and inspiration to me in many, many ways. What I want to do here is to focus on her punchline in the article, which was an assault on the characterization of affirmative action as special treatment for African Americans at the expense of so-called innocent whites. She shows how this narrative relies upon white entitlement as a baseline established by racial discrimination. Now, within employment discrimination law, this analysis is significant for moving away from understanding discrimination purely as a harm inflicted on workers by employers. Instead, its distributive character means that the harm to victims of discrimination accrues to other workers' benefit. So to reveal those benefits is to reveal property interests in whiteness and to call out its illegitimacy. The politics of affirmative action bear this out, as critics principally rally to the side of white workers cast as victims, not to the side of employers burdened by the state. Now, Harris rightly reveals and attacks the baseline of whiteness as property, but the article does less to specify the alternative baseline of racial justice that affirmative action aims to restore. Specifying that baseline is what allows us to name deviations as discrimination and to articulate affirmative action as its remedy. That, I assume, is why Harris calls her seminar Race-Conscious Remedies and not affirmative action, a point that I observed when I arrived here and actually had quite an influence on how I think about the field. Specifying this baseline is not always simple. Among other things, it raises difficult questions about intra-group distribution, in addition to the intergroup distribution central to Harris's analysis. Even if white privilege is pervasive, as it is, when considered across a lifetime and multiple institutional contexts, it seems difficult to say that all property held by whites is property in whiteness. but see Angela Harris's powerful talk yesterday. Even robust affirmative action programs aim to change white-dominated spaces into integrated ones that still include some white faces, just fewer of us and with less power. As Harris puts it in her critique of Wygant, quote, absent the history of overt and covert racial exclusion, many white employees would not have been hired in the first place and would therefore have no basis to claim seniority preferences. Notice that it's many, not all. So in practice, one faces the problem of which white people need to abandon which property in particular contexts. This is an intra-group distribution problem that cannot be solved simply by acknowledging the truth that in a just world, white people would have much less. A related intragroup question concerns which people of color receive race-conscious remedies, as Devin Carbado has so carefully traced in his work on college admission cases like Fisher. So this paper is not going to solve the baseline problem, don't get your hopes up, but I do aspire to show how the slippage between remedial intervention and special treatment pervades all of employment discrimination law. It is not special to affirmative action, it is all affirmative action. There are 3 reasons to do this. First, if a baseline error can convert even the least controversial anti-discrimination interventions into special treatment, then we have a general basis to doubt all special treatment accusations. Second, if I can identify with precision the baseline error in the easier cases, then these same tools might carry through to affirmative action as well. Third, special treatment accusations dog reasonable accommodation of people with disabilities and pregnant women. Seeing all these continuities both amplifies Harris's insights and suggests why affirmative action cannot be cut loose without undermining the entire anti-discrimination project, rather than saving it, as some might think. Now, I'll start with a canonical Title VII remedies case that I teach as a bridge into affirmative action, which is the 1977 Teamsters case, where the Supreme Court found that the defendant employer and union had systematically excluded black workers from lucrative long-haul driver positions and confined them to less desirable local routes. This was classic intentional discrimination of the sort that even Justice Scalia purports to abhor. So as a remedy, the employer was ordered to give hiring priority to drivers who had applied for long-haul positions but were denied them because of their race. As new openings came up, they were filled with these black drivers, and these new drivers would receive retroactive seniority to the date that they would have been hired in the absence of discrimination. This remedy begins to reconstruct the non-discriminatory baseline marred by discrimination. Even so, it remains incomplete. And the court also approved a further remedy providing priority hiring with retroactive seniority for black drivers who could prove that they would have applied in the absence of discrimination, and had they applied, would have been hired in the absence of discrimination. So what interests me about Teamsters is the employer's objection to this remedy. The objection was that providing relief to non-applicants constituted, quote, special treatment solely because of their race, end quote. That is, the employer attacked this remedy as a form of affirmative action. Rather than rebutting this attack by denying the connection to affirmative action, I want to say, bring it on, right? Teamsters is an example of affirmative action, but seeing that helps to legitimize affirmative action rather than to delegitimize the Teamsters remedy. The point is fairly simple. Access to the priority hiring pool was allocated in part based on race. Only black city drivers were eligible and whites were not. Therefore, if you focus only on the allocation of priority hiring, that allocation distributes a benefit to black drivers based in part on their race. But that obviously represents a baseline mistake of just the sort that Harris posits. The more appropriate baseline is the distribution of long-haul drivers that would have arisen in the absence of discrimination. And the Teamsters remedy merely uses race as a tool to partially reconstruct that baseline.